So how should you respond if you suspect an employee is abusing or misusing sick leave? Well, firstly, two important things to remember. Under the Fair Work Act, you, the employer, have the right to ask for evidence when an employee takes sick leave. And the second point is employees on paid sick leave have an obligation to provide evidence that would satisfy a reasonable person. That's the wording that they use. Would satisfy a reasonable person that they need to, evidence that they need to take paid sick leave. So in many cases, it's a simple valid medical certificate stating their capacity to work is sufficient evidence, but often we get the question, how far can I actually go in investigating and verifying whether an illness is actually genuine? So look, if it's just 1 or 2 days, you might not bother with a medical certificate, but when it's happened a few times or for a long period of time, there's a few steps involved that you really need to move through. So firstly, it's about meeting with the employer and having a really authentic conversation with them, asking them why the increase in sick leave has been happening. You could even explain to them that often when employees are disengaged with their work or the workplace, that absenteeism is found to go up. You really are keen to have a frank discussion with them about how happy they are in the workplace and in their work with their work. And it might come out that actually they're not happy. And hopefully at that point you can come to a mutual resolution or solution to fix the problem that you discussed with them. But it's also about letting them know that the next time they take sick leave, they must give you a medical certificate. You really want to make sure that you're making that point to them. Otherwise, this can go on and on and on, and you haven't actually given that clear direction to them. So the next time they take sick leave, a couple of things can happen. Maybe they don't provide you a medical certificate and you don't feel you have enough information about what's going on. Really need to meet with the employee again and have a very direct conversation with them. Obviously asking them why they didn't provide you a medical certificate when you'd advised them that they must. Advising them that you want them to provide more information in order to plan for the business's needs. This is really important at this point. So the next time they take sick leave, they must obtain a medical certificate and let them know that if they don't, it will trigger a performance management process and they may be issued with a written warning. So you're starting to step things up here and you need those records that you've said this to them. The other option that could happen is that when they take sick leave, they do then provide you a medical certificate, which is great, but you still might feel that you don't have enough information about what's going on. So I'd recommend meeting with the employee again if that's the case. And again, having a direct conversation with them, letting them know that you need them to go back to the GP and obtain more information from the doctor about their capacity to work and any adjustments that might need to be that you might need to make for them, because you've become quite concerned about the increasing amount of sick leave that they've been needing to use. It can be helpful at this point to also let them know that you might need to send them to an independent medical expert, because you really need more information about what's going on, because you have a duty of care to keep, as their employer, to keep them safe and to make those reasonable adjustments if a GP deems that that's necessary. So it's important to realise that employers are entitled to investigate further, and if you're not satisfied with the responses and information the employee is providing you, then you should definitely start looking to gather more information. There's a few different ways that you could do this as well. You could ask the employee if you can speak to their doctor. Some employees won't mind that. Or what we've done in a number of cases is actually give the employee a letter which they then take to their doctor. And that letter usually has a series of questions in it, things you need to know answers to. So things like, how long do you think that this illness might last, or what support does the GP feel that the employee might need now in the workplace, or when they're better, there could be adjustments that you need to make even when they're through the illness that they're claiming to have. Look, if an employee does refuse to provide additional information or maybe they refuse to engage with an independent medical expert, you do have grounds to initiate a disciplinary process. Things to keep in mind there: has the employee actually had an otherwise unblemished record of employment? Always take that into consideration. And very important point here is just don't act too quickly in these situations. Don't make a decision based on an unsubstantiated suspicion that you have. Disciplinary processes should be undertaken slowly and carefully. Don't rush to dismiss an employee or to take action that would adversely affect their employment while they're still with you. And just remember, the Fair Work Act does prohibit an employer from dismissing an employee due to a temporary absence from work due to illness or injury. If the absence doesn't exceed 3 months, that can be either consecutively or cumulatively over a 12-month period. So dismissal should ideally only be considered after the employee has been absent from work for a total of that 3 months or longer. And after that 3-month period, an employer may be able to dismiss the employee on the grounds that they can't perform the inherent requirements of the role due to an illness or disability. Just finally, I wanted to point out that, there are definitely risks involved, some that I wanted you to be aware of. Dismissing an employee unfairly or handling the situation unfairly in the eyes of the Fair Work system, and it could result in a costly unfair dismissal claim or even a general protections claim. An employer whereof was recently actually ordered to pay $28,500 and add superannuation onto that in compensation after an employee was dismissed within 6 weeks for allegedly falsifying illness. So look, access to paid sick leave, it obviously plays a critical role in maintaining workforce well-being, and it's something that every employee will rely on during their career, but our advice is always to tread carefully and within the guidelines that I've talked through here. Look, reach out if you have any questions on this topic, or you'd like to book a meeting with me to discuss any HR topic or priorities that are going on in your business that you want a hand with. You can just jump on www.hrtactics.com.au/meeting and book a time that works for you, and we'll see you on that Zoom call. Have a great month.